It's Jury Rights Day. I was thinking everyone could introduce themselves, but I'm Allison, and my partner Raza is here with us. And we also have a couple awesome people from FIJA, which is a national jury institute that fights for the rights of jurors to vote in the way that our country was founded to establish them to vote, which we'll get into more. And Stephanie and Kristen are here from Freedom Grow, and they'll explain to you their mission. But I guess we want to start, Raza, do you want to start off and then just for a moment of explaining what jury nullification is and then letting our guests introduce themselves and their role in this subject?
Yeah, I'll just give a little bit of background. So Allison and I, we've spent close to 10 years working together, doing a lot of criminal cases, and a lot of our criminal practice has focused on what are called victimless crimes, drug cases, especially marijuana cases. And this is an area of the law where a lot of people think that what the law says is really out of step with what people's morality is. And the idea, especially on marijuana cases and a lot of medical marijuana cases that we did, where DAs are basically trying to lock people up for having marijuana, for selling it, growing it. A lot of people are outraged by it, and jury nullification is the perfect vehicle to help save people who are caught up in the criminal justice system. Jurors are basically the last line of defense against a tyrannical government. And even if the laws are really bad that get passed, it's ultimately the people in the community get to gather in the courtroom, have to listen to the case, and they decide whether this person is guilty or not of a felony. And while usually judges will just tell jurors that they have to only decide the facts and they can't consider whether the law is just or unjust, there's actually a long history of jury nullification in our country and the world, dating back to the Magna Carta in the 1200s in England. And there's been, and just in America, there was a lot of people used jury nullification to help escape slaves who were prosecuted for running away, or people trying to help escape slaves. There were a lot of time people applied it for prohibition, for moonshiners and people who got caught selling liquor. A lot of people think that jury nullification is what really helped end prohibition and pass the constitutional amendment to allow selling alcohol again. And then just in the drug war, especially once we started seeing all of these mandatory minimums and really harsh sentencing for these victimless drug offenses, a lot of jurors will acquit even if they think the person is technically guilty of having the drugs or selling the drugs, just because they believe the law is so out of line with what morality would dictate. Also in police misconduct cases, we've seen so many examples lately of police brutality and other types of bad conduct by police, and jury nullification has been used in those cases to sort of get back at the police. A lot of people think the O.J. Simpson case was an example of that. They'd heard a lot of the jurors had heard about racist police and misconduct, planting evidence, and so forth. And a lot of people think that verdict was sort of an expression of outrage against the police system. So it's got a long history of in America and the world, but people are still fighting this fight, and there's still a lot of people trying to stop jury nullification. In one of Allison and mine's federal cases, the federal judge threatened to lock us up if we mentioned jury nullification. And he ended up putting in jury instructions some language saying that basically jury nullification is illegal, and that it would not be a valid verdict if they applied it there. And it went up to the Ninth Circuit Court of Appeals, and we got an opinion saying you're not allowed to put those instructions on there. That's not right for the judge to tell the jury that it would be illegal to do this. So
unfortunately in that, they said it was harmless error, and maybe we can use that as an interlude to talking to Kirsten Tynan here from the FIJA, which maybe she can explain to us what that is. And also if you can kind of tell us what is like the challenge seem to be of the kind of the 20th and 21st century in getting jurors to understand and actually, use their rights as opposed to the prior centuries. If you can kind of tell us, like, what are the challenges and why doesn't it happen as often as it used to?
Sure. I think the first question was, what is harmless error? And that is one of the most infuriating things for me as a non-attorney to have learned about. It seems like it's basically just a blank check for judges and prosecutors to commit misconduct during trials and not get penalized for it. Basically, after the fact, a court will rule what they did was wrong, but that it wasn't significantly harmful, that it would affect the trial. So basically, they get to take a mulligan. That drives me nuts. The challenge is for getting jurors to know and use their right to essentially nullify. Another term for it is conscientious acquittal. But to use this right is A, convincing them that it's not an archaic thing from centuries past. It does have a long and glorious history dating back at least to 1640 is, I think, the earliest verified case that I know of. I believe that was the treason trial of John Lilburn. Don't quote me on the 1640 though. But not too long after that is the trial of William Penn in 1670, and that I'm 100% sure of because today, Jury Rights Day, actually commemorates that trial, and this happens to be the 350th anniversary of his trial, in which he was prosecuted for publicly preaching the Quaker religion in Grace Church Street in London, which was then against the Conventicle Act, which basically said you can't gather in groups of more than 4 outside of the Church of England and preach your religion. So he had violated that, and his jury, despite being imprisoned, having food and water, fire and tobacco withheld from them, and having no facilities for hygiene, they stayed in jail. Some of them stayed in jail a few days, refusing to change their verdict, and they found him not guilty. So those are very important cases in jury nullification history, but it still happens today. It is still a modern thing that people can use. And the reason people don't necessarily know about it is just what Raza was talking about. Basically, they're misinformed of it in court. Judges will and prosecutors will go to great lengths to try and dissuade anyone from telling them about it. We actually just had one juror rights activist spend the last 5 years fighting for his freedom, fortunately, mostly from out of jail, because he was arrested and falsely prosecuted for handing out FIJA pamphlets outside a courthouse in Michigan. And that case had to go all the way to the Michigan Supreme Court for him to get a ruling saying that he was not, quote unquote, jury tampering. So those are the lengths that you'll see judges and prosecutors go to prevent this information from getting to jurors. It kind of cracks me up because I've actually stood outside of courthouses and had like a federal marshal or some other police officer, law enforcement officer, come out. I actually had a federal marshal have his hand on his gun, which was holstered, but he was basically just touching his gun the whole time, getting into it with me over whether or not he was going to arrest me. And I thought, well, I must have the most powerful piece of paper in the country. I'm wielding my flyer and he feels like he has to be on his gun.
Now, we actually had that happen to us.
Stephanie, it happened to you. Stephanie, you want to tell us a little bit about what happened in Noah's case when you almost got arrested? Remember when Homeland Security came?
Yeah, we had like the FBI vans that were driving around.
Stephanie, tell us what happened.
The people who were trying to educate the public outside of the courthouse.
Stephanie,
were you part of that?
I'm here, but I don't want to interrupt.
You jump in. No, tell us you do your thing.
Okay, so I have Freedom Grow Forever, and let's see. We do court support. My first court support was in 1969 for Angela Davis in Marin County. There were hundreds and hundreds of people there. And when we did court support for Noah Kleiman, your client and my friend, the police surrounded the parking lot because we had signs about jury nullification, and we were trying to educate the jury as it came into the courthouse. And they didn't think that was a good idea. But it's happened in so many cases because we always take our signs with us. So they make us leave the signs outside. We leave somebody outside with the signs. But court support works. Allison knows that when the judge and the DA or the U.S. attorney know all these people are listening to them, they act differently. They don't act the same. And if jury nullification became a household word, I don't think people would be going to jail for pot. The reason it doesn't work is because people are not educated to even know what it is. I ask people all the time, no, I don't know what that is. And so education is key. We have to get people like Kirsten. I love you, Kirsten.
I told you were going to love her.
Oh my goodness, we have to be friends.
Guys, I'm wondering about the education. I think it's great to educate the jurors in the courtroom, or as they're showing up for the case, or if the judge can educate them. But why not start in school and make this part of the curriculum? We have this Common Core now. Why not make jury nullification part of that, and have people, if everyone knows it as kids, and it doesn't matter what the judge tells them in court because they already have that foundation of knowledge.
I would love for that to happen, but what we have noticed is we get a lot of good reception from homeschoolers, but in actual school situations, it's very hard to get in the door, especially in public schools where that is an institution that's controlled by the government and they have certain incentives. And this isn't necessarily something they're interested in promoting.
Well, I know like my kids' school would definitely be
homeschooled. Everyone's homeschooled right now, so now's the time to do it.
I should mention, one way we've been able to get a foot in the door in schools is, I've noticed ever since I was in high school, quite some time ago, still through now, roughly every 5 years, one of the Lincoln Douglas speech and debate topics that comes up is they debate jury nullification. So I'm always on the lookout. This happened, I think, about 3 years ago in actually, I think it was a national resolution. So it's all across the country at the same time. But for about 2 months, they debate jury nullification. So I'm all set to take advantage of that the next time it cycles around. I didn't realize
I bet you know what? I bet you I could get you to speak in my kids' school on their virtual town hall meeting. Maybe if you
that would be great.
It's a very progressive place. And these still people don't know about it. So so there's two things. One is like on this, for example, on this jury with Noah, we even had like a professor on the jury and they still couldn't even figure out this jury nullification thing. And Raza pretty much explained it to them at the midst of both of us going into custody.
And I have to think in that case, the judge's instructions probably had a huge effect. No one shows up to jury duty and wants to get in trouble for it.
But they really thought that they were going to go to jail for it. I can't even believe that. So that's the thing that's, I guess I want to discuss. It's like, it seems to me that the only way, you can't really get nullification by trying to tell them about it. It's usually done by coming up with, you would think, like where the jury is so inclined, you have to come up with like other reasonable doubt and kind of get them to kind of hang their hat on it.
Right.
That being said, we've been really unable in the federal. There's been like on all these federal cases, I haven't heard of it happening once of any federal trial for any marijuana case, at least in the last like 20 years.
I'd have to go through I've been trying to compile a list of all my marijuana related cases. Nothing comes to mind immediately as to whether it was state or federal, but I'll have to look through to see if there's a distinction there.
Yeah, I mean, the state cases, like Raza and I we spent probably 14 years doing state marijuana cases. But the thing is, we had the law on our side, so we would win, but like the law was on our side. I don't think that they would have just gone for it if the law wasn't on their side. Like, because then we had the medical law. But when it was time to federal court, it just seemed like, I don't know. People are just more intimidated now than they used to be. That's the other thing. What about that issue? Like, why are these people so intimidated in the jury box now versus back in these other times they were not intimidated?
Well, in these other times, they were actually told that jury nullification was a valid option. It was so commonly known that
Right.
you would be laughed out of court, or in the case of Samuel Chase, one of our Supreme Court justices, you could be impeached if you so much as implied that jury nullification was not allowed. Yes, indeed. We had a Supreme Court justice in United States history
Wow.
who tried to prevent jury nullification, and that was one of his charges of impeachment. Samuel Chase, look him up. His defense was essentially, you'll see a lot of quotes floating around jury nullification circles where he is saying wonderful things about jury nullification. Well, that is because in his defense, he was like, by gum, I would never say anything bad about jury nullification. That wasn't me. So it was kind of funny. But in 1895, there was a Supreme Court case in which the defense had, I believe they had appealed, this is Sparf versus United States. They had appealed saying that, hey, you didn't tell the jurors that they could nullify. It wasn't that they were misinformed, they just weren't told in the jury instructions. And at that time, the Supreme Court ruling was that this was so commonly known in society that no one had to tell them. If they knew about it, they should have known about it just from being in the culture that they were in. And so it wasn't error not to tell them about it. Since then, we've seen creep in the jury instructions from not telling them to strongly suggesting that it's not valid, to outright stating, as in the case of Noah Kleinman, and also as in the case of, I can't remember who it was in Kansas, but the Kansas State Supreme Court also had the same issue where jurors were told, you must vote guilty in these circumstances. Actually, I can't remember if the word is will or must, but the will and must language was ruled not permissible. Now, in that case, if that had been the only problem, then the Kansas State Supreme Court said we would have called it harmless error. But there were 4 different errors in that case. And they said, based on this idea of cumulative error, you could have each of these 4 errors be harmless, but in conjunction with each other, this package of errors then becomes harmful. And only because of that was that case overturned. So that was fortunate, I guess, but still, you see the lengths that they will go to kind of be like, how bad must it be before we finally do something about this? But yeah, it used to be commonly known. People didn't need to be told about it. And if you talked about it in court, it was fine. That has since crept to where we are now. And I think one of the areas that needs to have significant litigation, as was done in Noah's case, is these jury instructions. The other thing is juror oaths. Juror oaths have changed over the years. The juror oath used to basically just be kind of a generic thing that there was quite a lot of latitude. It could mean a lot of things, and it didn't in any way seem to exclude jury nullification. But now we're seeing oaths in different states. And I don't recall if this has happened in federal court, but I wouldn't be surprised if it had. But that the oath is now strongly suggesting to jurors that you have to follow the law as the judge gives it to you. And by gum, you just swore on that. You made a promise. You have an oath. There are a lot of people who take that very seriously. I take oaths very seriously myself, but my personal thought is, if I'm being coerced into taking an oath that's not correct, well, I can interpret that in the way that I feel suits my conscience. So hopefully people will understand that the government is playing by dirty rules. And if we're just going to play, straight up, okay, I said this, therefore I can't do it. Well, guess what? We just gave away our rights.
Right.
What do we do about situations, guys, where people, do they use nullification for bad, in bad ways, where, someone is innocent, they convict them because they don't like the person? Obviously that's happened.
Well, in that case, at least you have the right to appeal, and hopefully the Court of Appeal can turn around, if the evidence didn't support it.
I'll also point out that that's a lot harder to do than the other way around. When someone is being accused of something that they aren't going to be convicted, in order to prevent a conviction, 1 person out of 12 has to stick to a not guilty verdict. That will at least hang the jury. The trial could then be redone, but it will be under a lot more favorable circumstances for the defendant in most cases. They will have kind of seen the prosecution's playbook. They will have perhaps gotten a better plea offer if that's on the table. Maybe the prosecution says, okay, this isn't worth it to us. And in some cases, it just becomes so embarrassing to lose that prosecutors will stop. We actually just saw yesterday in the case of Curtis Flowers, his situation was he was convicted after it took 6 trials to get a conviction that stuck until last year when the Supreme Court overturned it. But he was accused of murder. His last conviction resulted in the death penalty. But how had he gone through 6 trials? Well, it was in Mississippi, and the prosecutor kept committing misconduct in case after case. In many of those cases, the prosecutor managed to get rid of all or almost all of the prospective Black jurors, so he would have practically an all-white jury in most cases. When the prosecutor didn't manage to accomplish that, he got some hung juries in there. So some of the cases were overturned for prosecutorial misconduct. Some were hung juries. His last one, a conviction, was finally overturned by the United States Supreme Court because of this racial rigging issue of his jury. But since then, he was in prison for 23 years and was released last year after the Supreme Court ruling. But up until yesterday, he was wondering, is there going to be a 7th trial? What's going on? But finally, the previous corrupt prosecutor had stepped down, and the prosecutor who took over finally dismissed the charges. So there is that possibility in those cases. But to convict an innocent person, you can't just have one person do that. You need all 6 or 12, depending on what size of jury it is. So while there are 2 sides to the coin, they're not evenly weighted. It's purposely made a lot harder to convict someone because we are kind of founded on the general principle that we would rather let 10 guilty people go free than to harm one innocent person. So that system was purposely a tilted playing field to begin with in favor of liberty.
So Kristen, we haven't really heard too much from you. You want to tell us what do you guys do, and a little bit about how that interplays with jury nullification?
So yeah, I'm a board member along with Stephanie Landa, Freedom Grow, where we just believe that nobody should go to jail for a plant. We've sat on a lot of trials, and we saw where just one person could have voted not guilty, but they were a lot of pressure was put on them, and as they were in the jury making decisions, and they weren't known, oh, should I do it this way, or should I do it that way? They're very, very scared when they're coming up to a trial and facing, what do I say? What do I do what the other jurors do and vote guilty? There's all this evidence, and there's all these snitches, people telling on each other, and they clearly broke the law. But bottom line, judge the law, and if you think it's a bad law, you can vote not guilty. Or if you think the law should not be applied in a particular case, you can vote not guilty and not be punished for it. So you cannot go to jail or get in trouble for your verdict. I want to say thank you, Kirsten. I love hearing you. You are amazing. I've been working with Kirsten. I'm just a big, huge jury nullification advocate, and I have been looking up to Kirsten and Feja's work for years and years. I go to them for all my jury nullification education. But I also want to say, the same conversation, we got a jury nullification advocate as well as an attorney, which I have had many conversations with attorneys, and a lot of them won't even discuss jury nullification. So my question I have for you, Allison, is what brings your heart and soul into this that doesn't bring the average other heart and soul of other attorneys into the conversation of jury nullification?
Well, I've been writing I've been into it for a long time. I wrote my first article about it right when I became a lawyer 18 years ago. I always knew that I always felt, well, here's the thing. I thought that when I was thinking about becoming a lawyer, I thought it would be actually pretty easy. I, learned about nullification historically. And then I thought this wasn't going to be too hard. I thought I was going to be able to win, obvious drug cases because it was so obvious that it was criminalized drugs. So I thought it was going to be able to be something I could get away with routinely. So it was kind of my plan. That was how I was going to do stuff. Now it turned out that fortunately with the marijuana stuff, we had a law that helped us. But one of my plans when I became a lawyer was to use nullification. And then I also knew if I set a bunch of cases for trial, especially cases that had, that we could always find some good issue and then that was also how we ended up resolving a lot of drug cases. And I kind of knew that if you push every drug case to trial, that will clog up the system. So those were like
Yes.
my two ideas. And then, Raza and I, try. So we had all these state marijuana cases where we really didn't have to use nullification. We used the law. And then we had this federal trial that was kind of like that was going to be kind of like, we were going to try it out because we were pushed against a wall. And we had this really scary judge who was threatening to put us in custody, and Raza was still able to kind of explain it to the jury. And we even had a professor, and then Stephanie was there protesting outside. And we even had a professor on this jury. Like, you would think like this guy would understand. And even if the judge said to them it was illegal, like a professor you would think would get that he's not going to get like put in custody over a verdict.
Part of the problem, I think, in the federal courts and courts in general is the jury is not allowed to hear what the punishment will be. Probably a lot of people on there thought, well, this is just a weed case, he'll just get some kind of probation. But instead he gets 18 years in federal prison for nonviolent marijuana.
But how dumb are these people? I don't even understand. Like, all this misconduct happens, and these fucking people don't even. They're not supposed to look it up. I'm not encouraging that they should. But you would imagine with all the bad shit that happens and the misconduct that happens, you can't just have not one person can figure this shit out and have misconduct in your favor. Like, not one person went and Googled this shit and said, oh, this is fucked up. Like, let's do this. That's what's so shocking. It's like, so that's the thing I think we should, how can we change this so people do? Like, it's crazy. It's just so stupid.
Let me push back against that a little bit. I am very sympathetic to every one of these cases, but earlier this year I gave a TED talk called Jury Duty is for Heroes, and I think part of the way we push back against it is to stop with the stereotype of jurors as, the standard trope is too dumb to get out of jury.
Not stupid. No, they're smart. Of course, no. It's like it's not a stupid. That thing I don't think stupid is the right word, because you're like professors. It's that you have to be, just that they're like their mentality is sheepish.
Yeah, that's
they have to
the
be
thing.
a little bit of a rebel too, and willing to go
well,
against.
here's how we get these juries.
Yeah.
I'm sorry. Oh, so I watched a lot of videos on training lawyers for how to do voir dire. And essentially what happens is anyone who does seem independent-minded, anyone who does seem like an activist, anyone who seems like they're not just going to be led to a conclusion, those people are going to be removed from the jury. So we actually have some training on our website for surviving voir dire. How do you get through jury selection without getting yourself in legal trouble, because it's illegal to lie during voir dire, but also not answer the questions in ways that will be likely to get you off the jury. And if you are going to be if you're looking at it and you see that, you can tell they're going to kick you out, what can you say before you leave that's not going to get you into legal trouble, but will at least kind of give a clue to the other jurors? One of the things that I think is kind of interesting about voir dire is essentially if you have attorneys who are trained to do things like ask open-ended questions, not yes/no questions, but things that will encourage you to talk. And as you've noticed, I like to talk, so it's something I would easily fall for if I wasn't very conscientious about it. And not only do they ask open-ended questions, but they'll leave an awkward pause just a little longer than you expect. That compels you to say more, like you're trying to keep the conversation non-awkward. So they have a lot of psychological tactics for getting people to spill their beans. And a lot of people who are activists, like the people in this room right now, we want, you get us started, we're gonna go. We're gonna tell you everything. And that is very bad during voir dire. That is a good way to get removed. The more you tell them, the more they know about you and are likely to decide to deselect you from the jury. So we have to train ourselves and train other people who are, when they're being called for jury duty, about these tactics, and make sure people understand you're not lying not to go on for a half an hour answering every question. It's not lying to answer a question with a question, etc. So if someone asks me, for instance, am kind of mad at myself because back in the day when I was in my 20s, I was called as a prospective juror for a drug case, and I was in voir dire, and I knew about jury nullification. By gum, I was ready to go take care of business. And I get in there, and I'm not prepared for voir dire. I'm telling them straight up what I think, and by gum, am I happy to do so, because I think my opinions are great and everyone should hear them. So I get asked,
Wow, we all have something in common here.
right? So I get asked, does anyone here, they're asking everyone who's in the questioning part, does anyone here believe in legalizing drugs? And I've got a shitty grin on my face. You're damn right. And then I get singled out. Which ones? All of them? Well, you might be surprised to find out that that is not a recipe for getting on a jury. If I were to do this again, I think in the future I would ask, legalizing what drugs, maybe come back with a question so that I'm not necessarily answering it directly. I guess it would be depending on how they ask, but if they ask me, what do you think of drug laws? I'm like, it's not something that affects me daily, which it's not. Do I have to tell them? Do I have to tell them everything I think?
Use reverse psychology.
Mm-hmm. There are ways to answer questions truthfully but unhelpfully that will keep us from being deselected. And I hope that at least everyone who watches this will give some thought to that if they're ever called for jury duty, because you are likely to be the only fully informed juror. And if you don't get picked, that defendant could be screwed. And in my case, I never found out what happened with that, but it did sound very bad because one of the other jurors was asked, do you recognize any of the witnesses? And he pointed out the police officer and said, that police officer is being investigated for, and I didn't hear what he said because the judge was shutting him up as quick as he could and getting him out of the courtroom so that we wouldn't know there was a corrupt cop on this case. And one of the charges, so that the guy was accused of possession of drugs and then possession of drug paraphernalia. Well, that sounds pretty bad. Drug paraphernalia, what's that? Well, in this case, it was a Ziploc bag because the drugs were in a Ziploc bag. They were trying to charge him and prosecute him for ownership of a Ziploc bag because drugs had touched it. These are the lengths that the government will go to basically, I won't even say prosecute, that's persecuting people. And jurors, if we don't get a fully informed juror on that case, guess what? That guy is toast. But don't get me started.
Yeah, right.
So what do you think we can do, Kirsten, just like all of us, to try to promote this on a, kind of everyday basis in the society?
Well, what I have been challenging people to do today is create your own fully informed jury. Find 12 people who don't know about jury nullification. Doesn't have to be just today. It could be in the next week. It could be this month. But get out there and educate 12 people. Maybe you find out that someone thinks some kind of case is unfair. Talk to them about it. Maybe you're out at a courthouse somewhere for some other reason. You know what? Bring a couple FIJA brochures or other organizations' brochures about jury nullification. Maybe leave them surreptitiously in the bathroom of a courthouse. I don't know. You might have put those down while you were doing your business and forgot to take them with you.
One time, although I can't.
One of Allison's cases,
Yeah.
we put jury nullification all over the bathroom.
The
police came and shut down the bathroom.
Yeah.
They shut down the whole floor. Nothing to move.
Wow.
They were so upset.
They said that someone had vandalized the bathroom and they had to then, but what was great about this actually, and first I was like, Raza and I were fucking dying. We're like, fuck. Actually, what worked out well was that they pulled all the jurors about it to see if they were intimidated, which we were like, this is so ridiculous. But some of the people we thought were going to be good were intimidated. So we got rid of them, which was the thing. We thought,
wow.
But she was intimidated by a jury nullification being vandalized in the bathroom.
Wow.
So that's another good thing about bringing people with you is you can see the jurors' reaction to those people, and that can also tell you. Yeah. A little bit. We actually had one person tell us after she had been called for jury duty. She sat in the jury. I don't know.
I think it's a jury assembly room where you sit before you get called to voir dire. So they were there all day. Most people sat there all day and never, nothing ever happened. But as people got called, the numbers dwindled. But they had computers there that people could use before they were on a jury, since they're sitting around with nothing to do. So she went over to each one and changed the homepage to the FIJA homepage. That way, every single juror who went to use a computer would be greeted by my website,
Awesome.
which was delightful. I actually don't know who this was, but someone who is involved in, I can't remember which county in California, but someone who is involved in sending out the juror notices started putting FIJA pamphlets in with the juror notices.
Oh my goodness,
Bless
great.
that person, because what an opportunity. And they probably put themselves at a little bit of risk for that. But certainly every single one of us can find 12 people and a reason to talk about jury nullification, whether it's some kind of case we know someone doesn't like, some kind of law someone doesn't like. On election day, I'm going to be talking about jury voting and how it's your veto power over whatever laws that your community just is about to pass that you think are unjust. There's always an opportunity. And so 12 people, just, check them off. Get yourself a jury. If we don't create fully informed jurors, when we're the ones who are sitting in the defendant's seat, we're not going to have fully informed jurors.
This is true.
Yes.
Kirsten, before you go, can you tell me what you think about this? If you tell me what, just your opinion. If you, let's say you're on jury duty and like the cat's out of the bag, because sometimes they figure it out. What my advice would be at that point, if you're already like, they're going to get rid of you because you already revealed yourself, then say as much as possible at that point about the right of the jury nullification. So there's a point at which if you can get away with being on the jury, great. But if you're already like, done with, then you say as much as possible to inform the rest of the people.
Yeah, that's something that I really would work on more if I'm called for jury duty, because as much as possible is going to be very, very little. So you want to say something.
If the person's burned already, then you might want to ask them stuff like, oh, why do you think this is right? Blah, blah, blah. You can ask them a couple little things, whatever you get away with.
Yeah. The thing I learned from that case where I didn't end up being on the jury was that guy who said something about the cop being corrupt. Like, I didn't even hear what he said exactly, because the judge was loud and on a mic and getting the bailiff in there to escort him out and, threatening him if he's kept talking, he was going to jail. So there's a lot that they can do to shut you down very quickly. Yeah. So definitely try to say something, but give some thought ahead of time as to what you can say in a very short amount of time that will be, at least, you're not going to give the history and legal foundations of jury nullification, but maybe you can get someone to look it up when they go home that night on Google.
Yeah. And have you heard anything about, Kristen, any difference between Zoom trial? Have you heard of any trials on Zoom versus in person, and whether or not that promotes people's independence? Or what do you think about that idea as a kid? What do you think about that versus the mask thing in terms of this issue?
Are you asking me?
Yeah, what do you think?
Okay,
Let's say what do you think in terms of right now we have the chance, let's say, to either go to trial with masks on or have a jury on Zoom. What do you think would further promote?
I think these are both horrible. I don't know which is worse.
I know.
With a mask, you have the problems that you can't tell how the juror or how the witness, I assume they would at least not have a witness in a mask, but you can't tell someone's demeanor or whether they're understanding something, whether they're hostile to you or not. The social distancing is also a problem, because the further apart you are, the harder it is to have any sort of rapport going on. If the jury is sitting back in the gallery and everyone else is looking forward, how do they establish any sort of rapport with a defendant if they can't see the defendant's expression and things like that? Again, if the defendant has a mask, that's going to cause a problem there. But on Zoom, we're also seeing there is evidence that not in jury trials, but in hearings, defendants who don't appear in person with a judge are getting worse outcomes, whatever their hearing was about, than if they do appear in person. And it's that there's a psychological thing that's going on in these
They're getting worse
situations.
outcomes if they don't appear. That's
Right. If they show up by Zoom versus in person,
yeah.
They get worse outcomes if they show up by Zoom. And they usually don't have a choice, obviously.
Yeah.
But the thing about the jury is, okay, we're sitting here. Let's look at Stephanie. What's she looking at?
Right.
That's a juror.
I know what she's looking at. But.
Yeah, they're not looking at the defendant's demeanor and seeing, those sorts of things going on. Maybe I've got dogs in the background. I don't know if you can hear them, but I keep thinking, are they going to start barking any minute? So my attention's divided that way. What happens when we go to deliberate? What do I feel like Kristen and I or Stephanie and I, are we establishing a rapport the way we would if we're stuck in person in a room and sitting around eating our lunch together? It's just not the same. So it's not, I don't think there is, I'm an engineer by training. This is sort of a second career for me, but I don't think there is any evidence, or if there is, I haven't found it yet, of which is more detrimental to a defendant, the masks and social distancing and all the other measures taken, or a virtual trial by jury. I think they're both awful, and I wish I had some kind of answer. But I will say the National Association of Criminal Defense Lawyers has basically said it's irresponsible right now to have any trials by jury. I'm also not cool with that.
You know what is? I understand. So, like, we have a marijuana case coming up. It's a ridiculous thing with they say he lied by claiming he was growing. It's a ridiculousness, a perjury case. They were trying to Raza and I were like, they had so they hadn't really continued the court dates. They just got rid of a bunch of court dates, and then all of a sudden put us back on the calendar. Yeah. So we're like, well, we're not going to waive time. So the judge, she ordered us to actually appear in person in a week as a punish, just to fuck with us, actually. It's a misdemeanor trial. It's I feel like actually.
Yeah, if it's not safe to be there in person, and the only alternatives are things like masks or Zoom trials, which affect a defendant's right negatively, then what is the last alternative? Let them go and drop the charges, especially for these cases where nobody has been harmed. It is infuriating that a marijuana case should still be in play in this environment. That should just be off the docket.
Well, that one, they made up stuff. So now what they do is, instead of charging marijuana, so this is the craziest thing. So, what goes on right now, this is what they're doing. So there are some cities like Santa Barbara, for instance, where this case is, where in order to get a license, you had to have already had a marijuana collective. So in Santa Barbara, okay, you sign an affidavit saying I was already growing. Now they're saying that they were lying by pretending they were growing. And they're charging them with perjury. So they're not even charging the marijuana crime, some ridiculous related thing. But yeah, it's a really screwed up situation. You have to really decide, I agree with you. I think the only answer is they should weigh the evidence, the need to prosecute against these two bad alternatives.
Yeah, I just feel like our rights are not for when everything is sailing smoothly and everything's happy and wonderful. We don't have the First Amendment to protect us in order to talk about puppies and rainbows. It's for when there's upheaval. It's for when there's unrest. It's for when there's disagreement. And the same is true of trial by jury. Trial by jury isn't there to protect people who don't need protecting. It's there to protect the accused from abuses by government. And we're now in an environment where the government has decided that we're going to throw out our rights because it's difficult. Well, guess what? They should have had a plan in place long before this ever happened. They had time to figure this out, and they didn't. So I feel like at this point, it should just be off the table for them to be prosecuting almost everyone. Almost everyone.
I agree with that. Raza, we have to get to that motion here.
And it's supposed to be the prosecutor's job to do justice and to decide which cases are worth bringing and which are not. So I think that they really need to recalibrate.
Absolutely.
Decision making, and they can be a good responsible prosecutor by dropping all of these victimless cases and focusing on actual serious crimes that are endangering people.
Yeah, it's just, I can't even believe how many people are still in prison. You're seeing, when this whole pandemic started, the word was, you're not supposed to put anyone else in jail who doesn't absolutely need to be there, and we need to get as many people out of jail and prison as possible. And that hasn't happened. So I think it's just that the government doesn't want to cede its power. And once it starts acknowledging that people don't actually need to be in prison for these things, after the pandemic's over, how are they going to reestablish that? How are they going to gain that control back? So they don't want to let go of control. And so they're behaving beyond irresponsibly, just incredibly cruelly to people by keeping these things in place.
I agree. Just Stephanie, tell us what's going on with these two guys that you are putting this poster up about.
Oh, I was just putting up.
I know, but let's talk about them.
For life. So these guys got, these are both in jail for life. John Knox has 3 30 years consecutive sentences. All these people are in jail without any money. They've been in jail for 20 years and they're not getting out. It's like life.
Nobody's getting out for COVID either. We tried for one of your guys and they wouldn't. The Bureau of Prisons said no. It's, you know.
That's insane.
They'd rather die themselves than let people out because they're getting sick themselves.
Yeah.
They're not getting sick.
We actually just had in Great Falls, Montana, an interesting case where a juror didn't want to wear a mask in court because he had trouble breathing. Well, we have a statewide mask mandate for indoors. So he shows up to court. He does what the jury summons orders him to do, shows up, but doesn't wear a mask. Now, all of the judges in Great Falls locally had conferred with the sheriff, and they all agreed, okay, putting someone in jail for violating this isn't good. We'll just fine them if someone violates this. It'll just be a money situation. It won't be go to jail. Well, this judge was a visiting judge from a different county, and he got ticked off that he wasn't being obeyed, and he found this guy in contempt of court and put him in jail for 24 hours. At which time, while the guy was in jail, there was discovered an outbreak and 55 people in that jail came back positive for COVID-19. So he was willing to give this guy a possible death sentence for not wearing a mask in court instead of fining him some like $150 or something. Like that's the mentality of we have towards jurors. Imagine how much worse that mentality is for people who are prisoners. I just can't grasp how someone could lack such a conscience that they would do this for a living, understand exactly how the system works. Sorry, I'm getting a little emotional. And they're saying it's okay to risk these people's lives. But I guess it doesn't really mean that much to them because they've already done it. It's not like COVID-19 is the only risk anyone faces in jail or prison. So
it is really horrible. It's so sad too. Raza had a really good idea about how to do jury trials also right now, which is to do them outside. Why don't they do that? No, they could, in the summer, they could have taken over all these amphitheaters and then we could do a regular jury trial.
Yeah, there actually are some places that have gone to like colleges for their auditoriums or as you mentioned, a lot of theaters and performance venues are not being used right now. So there are some places doing that, but I haven't seen a whole lot of results as to how that is considered to be going, but that's something I'm definitely trying to keep track of.
But what Kirsten's saying is right. It's really sad how like you go into, once you're in court and just how, what you said is really right, that they're willing to like just kill off a juror because he didn't listen. And that's like the mentality once you're in the courtroom, like it's complete like lack of humanity.
There's an author, G.K. Chesterton, who doesn't normally write about jury stuff, but did in fact write a short essay called The 12 Men. And he kind of talked about why we have jurors deciding these things instead of judges. And he pointed out that when you're a judge sitting there day after day, you know, dishing out sentence after sentence after sentence, you don't see the person in front of you. You see the person you expect to be in front of you. So if you've had a lot of people who've had certain patterns, now you're just going to go on autopilot. And this is just another, you know, cog in the wheel, just another pawn. Here's what I expect from you. I'm giving you the sense. You're not connecting with the person. You're not establishing a rapport. You're not thinking about them as an individual human being. But when you have jurors, we've never done it before, most of us. People who have served jury duty more than once are not that common, and almost nobody has served jury duty 3 times, as far as I can tell. So you're not already used to it. You're not already expecting, you know, certain things to transpire, and you haven't gone on autopilot. So that's one of the things that I think is really important about jurors, and one of the reasons why I wish jury sentencing was more common in this country. It does have its own problems, but those I think are easily overcome with a few legal changes to the laws in those areas. But for the most part, most of the evidence I've seen, I won't say all, most of the evidence I've seen suggests that jurors are more merciful in sentencing phase when they have that opportunity than judges are.
Well, another case of Allison's, the judge really does threaten you. Like the cops get up on the stand and they say, oh, we're liars. We were taught to lie in school. That's what we do. And the judge says, yes, they're allowed to lie. Remember that, Allison, in Joe's case?
Yeah, of course.
I mean, so like the judges, I mean,
Really crazy.
I think you have to get rid of the judges because they are not fair. Like we don't get justice, we don't get due process, and now the government is complaining they don't get due process. Well, marijuana people haven't gotten due process since the 60s, since they started going to trial. So
Yeah.
It's hard out there, I'll tell you, but being educated would help. That's for sure.
I think that's definitely the thing we all need to keep in mind. Once you get inside the courthouse, you're not going to get any of this information accurately told to you, and you may be lied to and told the contrary and bullied by the jury instructions and intimidated by the oath and all of that. So we have to learn it before we get to the courthouse, and that's why the Fully Informed Jury Association exists. We want to empower everyone to know that when they cross that door threshold, you don't have to check your conscience at the door like you check your coat, you know, when you're going to a fancy restaurant or something. You take your conscience with you all the way into that jury box and all the way into the jury deliberation room, and you listen to it.
Yep.
And was a final thing, Kirsten, can you tell us, so what is the law generally in most states about where you can, like it's a certain distance from the courthouse where you can, you know, do flyers and you can't mention a certain case, you can just do it. What are some of the general law about it?
Okay. As far as I can tell, there isn't a general law.
Well, what's the, some of the, what are the most of it? Yeah, some of the,
that's why we never got arrested.
Yeah, for First Amendment purposes, there are 3 sort of categories of public property. The most protected public property for First Amendment purposes, shoot, the term is, I'm blanking on the term, but the sidewalk falls into it. I think it's called a public forum. And it's basically the fewest restrictions that the government can put on that type of property. So imagine you're sitting inside a courtroom and a trial is going on. Are you allowed to just stand up and start screaming jury nullification? No. Something's going on in there. Some amount of order has to be kept. So your First Amendment rights are different in there than, let's say you're out on the public sidewalk. There's a lot of traffic. There's people coming and going. There's horns honking. You know what? You don't expect a calm, quiet environment in there. But you do expect to have a lot of different things going on. A lot of, you're not sitting out there like trying to concentrate on something. It's a totally different environment. So for First Amendment purposes, a public forum, such as the public sidewalk, is the most protected for First Amendment purposes. Beyond that, how that is interpreted is not consistent from place to place. We pretty much, we pretty much kind of have to look at it case by case. And when I have a group who goes out and wants to know what they can do, I will look up the local ordinances that apply. I will look for any administrative orders that the chief judge of the court may have posted to see what that says. I will actually have a couple friends of mine who do GIS and map making work look up to see exactly what each piece of property is. We actually had people in Pennsylvania who the court tried to chase away. The court was a county court. They were standing on a city sidewalk, and we knew at the time that the county and city did not get on well with each other. So we used that to help them assert their First Amendment rights on the public sidewalk that was owned by the city. The county, the guy in charge of security for the county courthouse came out and told them that it was against the court's security policy for them to be standing where they were. And I was like, I need to know, I mean, exactly where you were standing. And so we narrowed it down to a square of sidewalk, you know, they were standing on. And I went to my friends, I was like, who owns this piece of property? Is this part of the county courthouse campus, or is this part of the city? And it was part of the city. The county had no business telling them whether or not they could be there. So it's really very, very much case by case. But I will say, if anyone does need help trying to figure out what's going on in a particular place, I'm happy to dig into my research bag of tricks to try and help figure that out for them.
Thank you. That's awesome. Howard, do you think we have any more questions? Anything else you want to know, talk about?
I think we're good.
Well, you know what I was going to do? I was going to put this up on our website, and I'll put everybody's contact information if that's cool. So like if people want to contact Stephanie or Kristen or Kirsten, you know, we'll try to just, you know, publicize this obviously. And one last thing I was going to ask Kristen, have you ever seen, because I wish I could have done this had I done Noah's habeas, I would have done this, but anyway. Have you ever seen it like come as a habeas issue where the government takes away the protesters on jury nullification? Has that ever come up like and has it ever prevailed?
I'm not totally sure what that word means.
Well, like let's say so like on the direct appeal, you can't take stuff outside. Okay, so direct appeal, you have to stay in the record of the case. And habeas corpus, that's like where you can go outside the record.
Okay.
So that's
I'm going to say no, I haven't seen that.
Okay, cool.
That said, you might ask Roger Roots, who may have, he probably is a little bit more familiar with the breadth of kinds of cases as far as that goes.
Well, one thing that would be cool, I think, would be like what we could have used, like I think, is if somebody is there to like kind of be the observer and like maybe do like a declaration as to what happens in case the person gets convicted, and then later they can use that as like contemporaneous notes as to like it's, you know, things that happen in the jury, whatever. So that would be something kind of, I think, the next level where we should do stuff to memorialize that action and then be able to utilize that. Right,
definitely.
Well, thank you everyone for coming. This is super fun, and I'm excited we're doing our part today to spread the word of what has happened.
Happy Jury Rights Day, everyone.
Thank you. It's an honor to be on here for everyone. Thank you. Thanks, everybody.
Thank you for having me.